Civil liberties are in focus this month as South Africans prepare to commemorate Human Rights Day on the 21st of this month. Let's look at basic human rights in the workplace and the do's and don'ts for employers. I am joined now by Thapelo Malakoane, who is the legal consultant for employment law practice at Cliff Decker Hofmeyer. Thapelo, thank you so much for joining us this evening on News at Prime. Now, let's shoot straight into it. What are the legal responsibilities of the employer when it comes to ensuring that employees are safe from discrimination?
Good evening, Masa. Thank you for the opportunity. Masa, employers in terms of the Employment Equity Act, are obliged to eliminate all conduct which may amount to unfair discrimination. Should they not, they may suffer grave consequences and damages. Now, Masa, as I said, only unfair discrimination is prohibited. We need to understand that there is fair discrimination. There are general laws such as the fact that a person must retire at the age of 60. However, it does not amount to discrimination to say if you are above the age of 60, you cannot continue working, but allow a person below the age of 60 to work. However, at the same time, it may amount to discrimination to say a person who is 35 years cannot be a secretary, but a person who is 20 years old can be a secretary. So age can be used as an element of unfair discrimination or fair discrimination in certain instances. Now, the obligation of the employer is to ensure that their policies do not discriminate. They also create an environment where the employees do not discriminate against each other. I would say those are the obligations of the employer.
I'm actually glad you cleared that up when you were saying unfair versus fair discrimination, but, because it does sound a bit of an oxymoron there to have fair discrimination, but you've kind of explained that really well for us, Thapelo. My apologies. So when we're talking about a place of work, this is where people are people who come from different societies come to meet at this one place as well. Now, an employer can do what they can by creating those policies, as you've just mentioned now, Thapelo. But what happens when it's an employee that is discriminating against another employee? So what grounds does an employee have to take action against the employer in that kind of event when the employee is the one discriminating against them?
Indeed, Masa. Now, you have employees may discriminate against each other. What is important is where the discrimination is happening. We may be employed by the same person and we meet outside the place of employment and I discriminate against you. The employer would not be liable. However, if such discrimination happens at the place of work, then the employer is liable for such discrimination. Now, on the grounds of an employee to raise a claim against an employer, there is a concept of common law called vicarious liability, where an employer is liable for the act of an employee. So whatever the employee does at the place of work, the employer is liable. That is a common law principle which is very, very tricky. Luckily, the Employment Equity Act came into place and removed the reason for an employee to rely on vicarious liability, but to rely on the Employment Equity Act itself to say, I was at work, I was discriminated against, I am holding you, employer, accountable. Now, the Employment Equity Act is not there to redress or make the discrimination correct, but it is punishing the employer for failing to create an environment where an employee cannot be discriminated against. So, briefly, the grounds of an employee to bring a claim against an employer are contained in the Employment Equity Act, not the normal common law, where you can say I've been discriminated against, I want redress, that is no longer necessary if discrimination happens at the place of work. The Act has given employees grounds to actually bring a claim against the employer.
And while it is encouraging, Thapelo, that these acts are in place, the law is in place, quite often, when employees have to battle the employer, it's always a David versus Goliath type of situation. From your experience as well in the legal sector, what are the key points for employers to look out for regarding discrimination against their employees?
Marcel, for employers, it is very, very important that I do understand that there are big employers, there are also small employers who may not afford to have policies in place to actually avoid discrimination. However, it is important that you have policies in place to avoid discrimination, and such policies must be looked at by a trained legal person to ensure that they are compliant, because it does not help to have a policy which is not compliant, which is not legally vetted, and you might not be protected whilst having a policy. If you have a policy, ensure that you get it legally vetted and it protects you as the employer from claims from other employees of failing to create an equitable environment in the workplace. I would say one key thing to look out for is have a policy, get it legally vetted, and you might be safer later when a claim is brought against you.
And do you find that employees are hesitant when it comes to tackling these cases of discrimination from employers specifically?
The Employment Equity Act, fortunately, allows one, depending on your financial situation, that is, to approach the CCMA, which is very, very accessible and is not at all costly. However, for people earning higher salaries, they are obliged to go to the labor court as opposed to the CCMA. Now, perhaps I wouldn't say people do not want to bring those claims. I would say people are not perhaps educated. That would be my view.
And I guess also financial constraints would also play a role in some cases as well. But before I let you go, some of these laws are quite interesting. I was looking at this, and it says that the employer has a right to monitor communications within the workplace as long as you're aware as an employer. So basically, they can check your emails, they can check your internet and what you're searching, your telephone calls, and images as well. Am I correct in that?
Indeed, it does depend. Most people who work at the offices, they use an employer's laptop, for instance, and that laptop is for you to work. Now, if you perhaps started running another business on the employer's laptop, and you would say, no, employer, you're not allowed to check what I'm doing with your laptop, I don't think we would have anarchy if that was the situation.
But let's say it's your personal laptop. Let's say it's your laptop. It's your personal cell phone that you do use for that employer as well. Do they then still have that right to be able to say they want access to your communications?
It does depend on the actual circumstances. However, and on another level, if you are employed from 9 to 5, you are expected to be working. Now, during that time, your time is the employer's time. Whatever you do during that time is for the employer. If you are on your phone for 30 minutes on end, and an employer says, I want to see what you are doing for 30 minutes on your phone, it is only fair that because he pays you for that time, he or she pays you for that time, they may request. However, if circumstances differ, as I said before, should there be privacy involved, which overrides the need for the employer to actually access those records, we may end up in court. However, it depends. It depends.
Yeah.
That's the best I can give you on that.
Yeah, it seems that one's quite a tricky one, right, Thapelo? But before, just one more before I let you go. The question of disclosing chronic illnesses, is this necessary? Is this an obligation of an employee to disclose, for instance, their HIV status to an employer?
I wouldn't say HIV status per se, or what exact illness you suffer from, depending on what type of environment you are working in. You do not want to find yourself in a situation where your sickness becomes more severe at the workplace, and the only people who can assist you do not know what sickness you have. So most of these rules and policies are created to ensure that workplace is safe, everyone feels safe, and should anything come up, you are able to be assisted. And it's also a two-way street. As much as if the company policy says everyone must disclose, even the CEO will disclose. It's not only about the employee, even the boss will disclose if it's a company policy. That's what I can say. It depends on the policy and what the purpose of the policy is. That is the most important, what the purpose of the policy is. In the event that you are of the view that, no, I do not want to comply with this, I don't think this purpose is reasonable or rational, you always have a right to approach the CCMA, the Labour Court, and challenge it.
Well, thank you so much for your time and sharing your insights with us, Thapelo. That was really helpful. That was Thapelo Malakoane, who is a legal consultant for employment law practice at Cliff Decker Hofmeyr.